Hello, everybody. It's great to be with you wherever you are signing on from. For those of you here on the East Coast, it's noon, and we are here on October 15th, the halfway point roughly in October. We are in the midst of fall, and wherever you may be, it likely is starting to feel a little chilly out there. Certainly here in New York City, that's the case. And we hope that as you find those extra layers and otherwise get adjusted to the new season that's here, we can provide you with some meaningful updates as we do every Tuesday. And so with that in mind, Kathy, if you'd go to the next slide, please, I'll walk everybody through what's ahead on today's program. So we have 4 presenters as is typical, and 2 of them will be with us from our Rochester office. The first one is Jackson Soames, who's an associate that I've had the pleasure of working with in lots of ways in the context of our healthcare practice. Jackson is a litigator and is going to be talking with us about efforts that Marriott, the hotel chain, will be taking in the context of an FTC federal trade settlement that is worth all of you hearing about. And then following that, we will be hearing from Jen Sin, who is with us from our Albany office. Jen has been on the program a number of times over the course of 23, and we're grateful to have Jen back. And the 2 presentations should work nicely together because Jen, in the context of her practice, of course, focuses on hospitality, as she has addressed with number of you before through her presentations here. And she's going to be talking about the hospitality industry more broadly and issues around data privacy and cybersecurity. So we think together you'll walk away with a pretty good understanding of what's going on in the hospitality sector generally and how that might apply to your own sector if that's not yours. Then we'll shift gears a little bit. Travis Tallarico, also with us from Rochester, an associate who has been on our program numerous times previously. And similarly, like Jackson, I've had the pleasure of working with Travis a number of times over. And Travis is going to focus on proposed DOL regulations concerning pay transparency that actually have expired. And there's some interesting implications concerning why that happened and what's next. And then we will shift to our Garden City office, just a little east of where I'm speaking with you from. And we'll be hearing from Kelly McKinney, who's an associate and who will be on the program today for her first presentation. We're delighted to have Kelly. And Kelly is going to be focusing on the Pregnant Workers Fairness Act, the federal standards that have really made some major changes in the space that the name suggests. And there's litigation, though, that has cropped up that really speaks to how it's all being enforced and where the points of tension are. So we wanted to make sure all of you heard from Kelly about that. So with that, let me switch over to introducing Jackson. If you wouldn't mind, please, Kathy, advance to the next slide. Jackson, as I mentioned, thank you, Kathy, is a regular on this program. Historically, though, Jackson hasn't been on. Recently, we're delighted to have him back because he always brings useful content for our viewers. And today, Jackson, putting on his cybersecurity and data privacy hat, is going to discuss the content of information memo that he also recently published concerning Marriott and its data security system. So Jackson, if you wouldn't mind coming on, there you are. We're really glad to hear from you, and I look forward to learning with the audience. Jackson, thank you so much.
And thank you so much, Gabe, and thank you, Kathy, as well. As Gabe alluded to, I'm going to be talking about Marriott and their recent settlement with FTC, as well as with some state's attorney general over their data privacy breaches that have been spanning, close to a decade at this point. So, Kathy, we can move on to the next slide. So as I mentioned, the origins of these data breaches with Marriott go back to 2015, when Marriott first announced that it would acquire Starwood Hotels and Resorts worldwide for $12.2 billion. And really, we can chalk up everything that's happened since then to the importance of due diligence and the importance of having a good cybersecurity program in place. Now, according to the FTC, the first breach happened, Marriott announced the first breach happened only 4 days after it announced that it would acquire Starwood. And Starwood notified its customers that it experienced a 14-month-long data breach in which the hackers gained access to payment card information for over 4,000 customers. And this is what the FTC has categorized as the first breach in this action. But then a second breach happened. In November 2018, Marriott announced that hackers had accessed one of its guest reservation databases in a breach that went unnoticed for 2 years. And in the course of that breach, the hackers and bad actors gained access to the personal information of over 339 million customer records. This is on a global scale, including more than 5.25 million unencrypted passport numbers. So again, just a very large data breach here. And then finally, in March of 2020, Marriott announced a third data breach in which malicious actors gained access to customer records, and the intruders accessed more than 5.2 million customer records, including 1.8 million records related to US consumers. And last week in October, Kathy, we can move on to the next slide. And last week, the FTC, after a course of a couple years long investigation, entered a settlement agreement with Marriott. As part of that settlement agreement, the FTC, they made certain allegations about Marriott's failures, including, as you can see there, failure to implement appropriate password controls, to patch outdated software, to adequately monitor network environments and who was accessing certain network environments, and failure to implement appropriate firewall controls, and a failure to implement certain multi-factor authentication. And notably, the FTC also alleged that Starwood failed to comply with its contractual obligations and its own internal policies regarding the requirements that it was supposed to have for multi-factor authentication. And in the settlement, the FTC has, made certain requirements that Marriott has to follow now. Most notably, it includes, overhauling and implementing a brand new data security system. These new safeguards that have to be put in place, they may sound familiar to a lot of you. They're kind of standard in the industry these days. It includes having data security training for its employees, drafting an incident response plan, implementing data access controls, implementing multi-factor authentication for remote access to its systems, encrypting certain personal data, as well as implementing monitoring procedures. And as I mentioned, this is kind of very typical for a data privacy security system at this point. If these sound new to you, maybe it's time that you review your own data privacy security system to make sure that you're up to standards. But in addition to those new implementation of the data security system, Marriott will also be required to twice every 2 years, they have to have a third-party assessment of their data security system. And that's got to go on for the next 20 years. Marriott will have to annually certify that it's in compliance with this FTC order. It has to provide customers with a process to request that Marriott delete their personal information. And there's also data minimization requirements. So Marriott can only retain personal information for as long as necessary to fulfill the purpose for which that data was initially collected. And as I mentioned at the outset, the FTC investigation isn't the only thing that's going on with Marriott. Kathy, if we move to the next slide. Announced on the same day, Marriott also entered a settlement agreement with 49 states' attorney general and the attorney general for DC, in which Marriott agreed to pay a fine of $52 million related to the breaches. And as I mentioned, these were 49 states' attorneys general In addition to the Attorney General for DC, the only state not involved was Maryland, which might not be surprising considered that Marriott is headquartered in Bethesda. But in addition to these two settlements that are going on, there's still a class action suit involving Marriott's data breaches, and this has been going on for over half a decade at this point. All the cases were consolidated in 2019. As I mentioned, it's still ongoing. It's kicked around in the Fourth Circuit for a little bit, then up on appeal and back down. So, there are significant costs that have been tied to these data breaches that you should be aware of. And that'll wrap it up for me. Thank you, Gabe.
And I thank you, Jackson, very much for coming on and providing the audience with some context around this Marriott activity. As I mentioned in my introduction, certainly, we view this background as useful regardless of the industry, because all of us tuning in should be paying close heed to cybersecurity and data privacy practices. And as I noted further, we have the good fortune of having Jen Sin with us as well. Jen's going to provide a broader or complementary perspective, as it were, from her vantage point with the practice that she leads, focused on, among other areas, hospitality. She also has written an information memo that recently Bond published, and Jen's going to highlight some of the key takeaways that all of you should be thinking about. So Jen, we're so glad to have you back on the program, tuning in, or rather signing on from our Albany office. And we thank you very much for your time. Please go right ahead.
Great. Thank you, everyone. Thanks for having me on. Always happy to join you all. I actually don't have any slides to share because mine isn't so much an update as it is a gentle reminder to our folks listening today. As Gabe mentioned, I had put out an information memo a few weeks ago regarding data privacy, and I geared it towards my hospitality clients, although the messages in there apply to way more businesses than just hospitality. And as it turned out, I was very, very timely because shortly thereafter, all this information came out, that the settlement came out regarding Marriott. So obviously a good time to remind everybody about some things you should be thinking about as far as cybersecurity. Obviously the Marriott settlement, $52 million, 339 million consumer records accessed, obviously a very, very large and concerning matter. So good time for everybody to be thinking about cybersecurity, consumer data privacy, et cetera. So, the reason I had geared my information memo towards hospitality is because hospitality industry can be a particular target for cybersecurity issues, but those are risks for pretty much any business nowadays. One of the reasons we've seen, I suspect, a lot of hotel cybersecurity breaches because they do have so many different kinds of data. So many access points for consumer data. You've got card readers, point of sale, you've got guest Wi-Fi, you've got IoT devices. So we've seen that, but this is an issue for all different kinds of businesses. So, as a 10,000-foot update reminder to everybody on the webinar, what are some things you should be focused on? What should you be doing? First, foremost, you should be making sure you're keeping up with those best practices, some of which, we just discussed. So those would include things like performing regular risk assessments. Very important, should be doing that. Training your staff regularly on your cybersecurity policies and risks. Keeping your software and your hardware updated, also very important, can be a big risk, and that's one of the things that we saw was an issue with Marriott. Requiring multi-factor authentication to access email and networks, and network files, excuse me. It's another one that we have seen in our practice, we've seen in the news, can be a big risk if that's not happening. Keeping up with external threat monitoring through a cybersecurity vendor, also very highly recommended. And requiring complex passwords and end-to-end encryption. Those are all things you're all probably familiar with or on your radar screen, but good reminder for everybody to be thinking of those things, keeping up with those, keeping up with the current best practices for those things. So what else should you be doing, particularly for clients in the hospitality industry, but except for many other kinds of businesses? What are some other things that might be thinking of keeping on your radar screen in light of some of these recent actions? So one thing that I did want to point out to our hospitality clients in particular was to make sure you understand what's called PCI DSS. So that is the Payment Card Industry Data Security Standard. So PCI DSS provides technical and operational requirements that businesses should be familiar with. Now, those they're not part of a law, they're not part of any sort of government regulation, but compliance with those is typically required by the major credit card brands. So something to be familiar with. Another one that I recommend to clients is to review your cyber insurance policy. Cyber insurance is so important in protecting the business. But I like to tell clients, make sure you understand before you need it, make sure you understand what coverage you have, what is covered, and what is excluded. Exclusions from the policies, very common. Good to know now before you ever need it, what is excluded, so you're familiar with it and you're aware and you're complying with everything you need to be complying with. A very common exclusion is the policy might require businesses to maintain appropriate procedures and controls to protect against cyber attacks. And it could exclude coverage if those were not in place. So one thing we have seen is multi-factor authentication. Does your policy require it? If it does, are you using it? When you applied, did you note to what extent you're using multi-factor authentication? Something to be aware of as a possible exclusion from coverage, should you have to ever use the insurance. Cyber insurance policies might include a retroactive date, so you should be aware of if the act, we saw it in Marriott, there was a long term of breach that wasn't discovered perhaps for some period of time. Make sure you understand the dates on that, what periods of time are covered and whatnot. Other common exclusions, bodily injury, a lot of times hardware and physical property damage is excluded. Failure of critical national infrastructure is typically excluded. There might be jurisdictional limits. So the takeaway being, talk to your broker. Generally a good idea. Make sure you understand your coverage, what's excluded, and do you have all the coverage you need. Something else you can think about and make sure you're keeping on your radar screen is making sure you're familiar with the legal obligations, right? So I'm sure folks on this call are familiar. You've seen the updates from bonds, but again, figured it's a good time to just refresh everybody's memory about the SHIELD Act, the New York SHIELD Act, that is Stop Hacks and Improve Electronic Data Security Act. If you're doing business in New York, you should be familiar with it. So again, you're all probably generally familiar with it, but here's just a quick refresher for anybody on the call who's maybe starting to think again about maybe it's time to make sure things are up to date as far as cybersecurity. So the SHIELD Act is meant to protect unencrypted copies of these things. So social security numbers, it's a big one, somewhat obvious one. Driver's license numbers or non-driver identification card numbers, that's also covered. Now, also is to protect unencrypted copies of account numbers, credit card, or debit card numbers if they're in combination with required security code, access code, password, or other information that would permit access to an individual's financial account. And also those same account numbers, credit card, or debit card numbers, if circumstances exist wherein such numbers could be used to access an individual's financial account without additional identifying information, security code, access code, or password. And it also covers biometric information. So that's data generated by electronic measurement of things like of unique physical characteristics. That's fingerprint, voice print, retina, or iris scan, those sorts of things. This is another big one. Usernames or email addresses in combination with passwords or security question answers that would permit access to an online account. So those are all things that are covered by the SHIELD Act. So businesses that are in possession of that kind of data are required to take steps to ensure that it is physically and technologically secure. It's being disposed of in a reasonable amount of time in a safe manner. Also need to have that written cybersecurity program that meets certain requirements. So all very important. And I also suggest to clients, as you're refreshing that and making sure you're up to date on those sorts of things, to be familiar with the notice requirements should a breach occur. Hopefully you'll never need it. But if you did, it's a good idea to know those rules now before you ever need them. Should you have an incident and you're working through your incident response plan, it's good to be already familiar with what does SHIELD Act require and what are your notice requirements should that come up. So the SHIELD Act requires that any covered person or business notify New York State residents about any unauthorized access to their private information. Generally, that has to be done as soon as possible. Now, there are some narrow exceptions. One of those, for example, is at the explicit request of law enforcement agencies. That can be delayed a bit. If the FBI is involved and they're actively pursuing an investigation and they ask that notification be delayed, that's one of the carve-outs. But generally, it has to be done as soon as possible. There is a provision to allow for substitute notification in certain cases. If the cost of providing individual notices would exceed $250,000 or the number of affected individual exceeds 500,000, obviously a very large breach, hopefully not going to be relevant, but something to be aware of. And aside from notifying the consumers, you're also going to need to notify the New York State Department of State Division of Consumer Protection, the New York State Attorney General, and the New York State Division of State Police. So again, hopefully never need it, but good idea to make sure the folks at your organization are aware of that. Those who would be responsible for that are aware of what the rules are. And we've talked a lot about consumer data, but one thing to keep in mind also is to make sure that you're complying with employee privacy laws. If your business is using electronic devices to monitor or intercept employees' phone transmission, emails, or internet usage, you do have to provide a formal notice to employees. And I think Bond has updated folks on this, but a good reminder, do have to give that notice, and the notice has to be posted in a conspicuous place and provided to employees upon hiring. So again, just a broad strokes overview, reminder, refresher for the folks on the line of some things to be aware of, some best practices, and just a reminder that cybersecurity threats are a big threat to folks in hospitality, but all different kinds of businesses.
Jennifer, thank you. That was extremely useful. And really, by outlining the nature of the threats from a categorical fashion as you did, and to run through some of the relevant law, you've given the viewers a really useful playbook. And of course, we here at Bond are always available to be of support. One of the areas of practice that we have is our cybersecurity and data privacy group, of which both Jackson and I and Jennifer, I believe you are as well, a member. Notwithstanding the three of us, find the attorney you work with most comfortably, and we can be of help to you. Let's hope you never need it, of course. Let's move to our next speaker for the program, who is Travis Tallarico. And again, thank you, Jennifer. And Travis is back on the program from Rochester. He's an associate who spends a lot of his time working in the litigation space, also touches on health, where I've had the chance to work on projects with Travis, and we're glad that Travis is back on the program, very much a regular, and he is here to tell us about these proposed regulations that I was mentioning at the top of the program that have expired, which doesn't always happen. There's usually an intention behind it, and we want to know a little bit more in terms of the context, Travis, as you can share. Why do you think the Department of Labor has let the proposal lapse, and what's next?
Thanks a lot, Gabe. And hello, everyone. As Gabe introduced me, Travis Tallarico is a regular presenter here on the webinar. And yeah, as Gabe alluded to, going to be walking through the expiration of the proposed regulations regarding the New York State Pay Transparency Act. Just as a bit of background, so the full law went into full force and effect on September 17th of last year. And around the same time on September 13th, the DOL had rolled out some proposed regulations to provide what would have been some much needed clarification on some of the ambiguities of the law as is currently written. But we've gotten to the point where last year, even after a public comment period, the proposed regulations did in fact expire. So we're left with the plain language of the statute as it is currently. So I figured this would be helpful to just walk back through exactly what the pay transparency law is, the history of it, and discuss what might be coming down the pike moving forward. So if we want to jump to the first slide, that would be great. So, and a lot of this might be refresher for a lot of us on the program. So hopefully this isn't too redundant, but I think good to just touch base on exactly what the law is. So the pay transparency law was designed with the purpose of generally sharing more information about pay and pay ranges for an available position. Now, the intent behind it is to help close the pay disparity or to reduce or eliminate pay equity, be that for various protected categories where the general aim is to have equal pay for all individuals. This is somewhat related to the enaction of New York labor law section 194A, which was a prohibition on asking about an employee's pay history, which was intended to disrupt pay discrimination based upon protected characteristics, as the pay transparency law is. And these laws generally require employers to disclose information regarding pay or compensation range for that position during the hiring process, and specifically here in the job postings. Next slide, please. So as I mentioned, the pay transparency law statewide in New York State was initially enacted December 21st of 2022. The amended and what is now final version was signed into law September 17th, 2023, and it's codified at labor law section 194B, which the main requirement of it is for covered employers to post a range of pay on job ads, creating some record keeping obligations and recourse for aggrieved persons and penalties for violations. Next slide, please. Thank you. So as a refresher of who it applies to, so it applies to private sector employees with 4 or more employees, employment agents and recruiters. It does not apply to public sector employees. And it does not apply to temporary help firms, as is defined in labor law section 196.5. I won't read that full definition for us here, but it's your standard temporary help firm. Now, the main points of what the law requires is that employers must ensure that any advertisements for job, transfer opportunities, and promotions that can or will be performed even partially in New York State must disclose the compensation or range of compensation for the position and a job description for the position if one exists. In terms of the maximum and minimum salary or hourly range that the employer in good faith believes to be accurate at the time of the posting. And also, if the position is paid solely by commission, an employer can satisfy the requirements by disclosing just a general statement that compensation shall be based on commission. As with most laws that New York State rolls out, there's an anti-retaliation provision which prohibits discriminating or refusing to interview, hire, or promote an applicant or a current employee for exercising any of their rights under this law. And there are some monetary penalties for violations. A person claiming to be aggrieved under the pay transparency law can file a complaint with the Department of Labor, and the DOL can and will investigate and potentially impose civil penalties of $1,000 up to $3,000 for a violation of this law. So a few major requirements or definitions that are contained in the codified version of the law. One is that it applies to jobs that are physically to be performed, at least in part, within the state of New York, which includes, as mentioned earlier, a job promotion or transfer opportunity that will be physically performed outside of New York, but even reports to a supervisor, office, or other work site in New York. Advertise is defined as to make available to a pool of potential applicants for internal or public viewing, including electronically, a written description of an employment opportunity. And as we also mentioned earlier, range of compensation means the minimum and maximum annual salary or hourly range of compensation for a position that the employer believes in good faith to be accurate at the time of the posting of an advertisement for such opportunity. Now, if we go to the next slide, thank you. So as I mentioned earlier, the DOL had published notice of proposed rulemaking to clarify a lot of ambiguities which had arisen in relation to how the statute is currently drafted. As an example, the proposed regulations contained a definition of what an advertisement specifically consisted of, defining the medium of what an advertisement was. But however, the rulemaking was never finalized, even after public comment period, as I mentioned earlier. So we're currently back, kind of coming full circle to the plain and somewhat ambiguous reading of Section 194B as it is presently drafted. Don't exactly know what to predict coming down the pike on this, if there will be another round of proposed regulations that may eventually actually get finalized and and published. I would imagine that such would be would be something that would be sought by the public, because when the Pay Transparency Act originally got introduced, there was a lot of questions seeking clarification about the scope of it, and exactly how it applies. So unfortunately, for now, we're going to have to just wait and see if there's any forthcoming guidance from the DOL on this. And I think that was the last slide there, Kathy.
All right. So thank you so much, Travis. That's really helpful. And as you pointed out at the end of your comments, we'll just have to watch closely as to what DOL is going to do. But for now, the plain language of the statute is controlling, and really glad that you could walk everyone through and help us think about the implications today. Please come on back if and when those regs do drop, and if there's something more to talk about.
Sure.
And in the meanwhile, let's switch to our final speaker for this afternoon's program, and that is Kelly McKinney. Kelly is with us on the program for the first time. We're really glad to have Kelly with us. She's an associate in our Garden City office, and she is prepared to discuss the Pregnant Workers Fairness Act in the context of her work in the labor and employment branch of our firm, where she is involved in issues relating to this act, and can tell us about some of the litigation that has been brewing and starting to define essentially how this act looks in practice. So Kelly, please go right ahead and welcome on the program. We're so delighted to have you.
Thank you, Gabe. So as Gabe just mentioned, today I'm going to speak about 2 new lawsuits that the EEOC just brought, alleging employer violations of the Pregnant Workers Fairness Act. And I'm also going to speak about how the act compares with other related federal laws. Next slide, please. So the PWFA is a new federal law that went into effect in June of last year. It requires that employers with at least 15 employees provide reasonable accommodations to qualified employees or applicants related to their pregnancy, childbirth, or other medical conditions. So to be a qualified employee entitled to these protections, the employee must have a known limitation. This is different than a disability under the ADA. The definition of a limitation is very broad, and it includes any kind of minor issue, a need related to the maintaining of the employee's health, or the employee just seeking healthcare related to the pregnancy generally. There is an exception, though, similar to the ADA, which allows an employer to refuse an accommodation that would constitute an undue hardship. So you might be asking yourself, what is the point of this law? We have the Pregnancy Discrimination Act that prohibits discrimination against pregnant individuals. And we also have the ADA, which requires employers to accommodate employees with disabilities. So why do we need the PWFA? So the Pregnancy Discrimination Act does not require employers to accommodate pregnant workers. And while the ADA does require accommodations, pregnancy itself is not a disability under the ADA. So the intent behind this law is to close that gap. The PWFA affirmatively requires employers to accommodate pregnant workers, which neither the Pregnancy Discrimination Act nor the ADA currently does. Next slide, please. So earlier this year, the EEOC issued its final rule to implement the PWFA, which contained definitions of some key terms. So a reasonable accommodation is defined as a change in the work environment or how things are usually done. So in the rule, the EEOC also provided specific examples of reasonable accommodations. So those include frequent breaks, sitting or standing, schedule changes, remote work, light duty, and most importantly, the temporary suspension of one or more essential functions of the job. Next slide, please. An undue hardship is defined as a significant difficulty or expense for the operation of the employer. This is the same definition that's used in the ADA. However, as I just mentioned, under the PWFA, an employer may have to accommodate an employee's temporary inability to perform an essential function of the job. So when the court is deciding whether an undue hardship exists in a case, the court will consider factors like the length of time the employee is unable to perform the essential function, the nature of the essential function, whether other employees are available to perform those functions, and whether the essential function can be postponed for a certain length of time. And just a note, the rule uses the same definition of essential function as in the ADA. Generally, that means any fundamental duty of the job. So to excuse the obligation to perform an essential function for a period of time can definitely be impactful on an employer. Next slide, please. So recently, on September 25th, 2024, the EEOC filed 2 lawsuits against employers, one in Alabama and one in Oklahoma, alleging that they violated the PWFA. In the first case, the employer Polaris is a vehicle manufacturer in Alabama. The plant in question here has several manufacturing lines, and line 1 required assigned employees to perform frequent overtime. So the employee at the center of this lawsuit notified Polaris that she was pregnant at her new employee orientation. And despite the fact that there were other lines with open positions that did not require overtime, Polaris assigned the pregnant employee to line 1. Next slide, please. So Polaris had an attendance policy that only excused absences for probationary employees for certain things like military leave or jury duty. Because she was a probationary employee, she couldn't accrue time that would entitle her to time off for her medical appointments. So when she missed work due to her pregnancy-related medical appointments, Polaris assessed attendance points against her. A certain number of these points would lead to discipline, including her termination from employment. Additionally, the pregnant worker had a note from her doctor restricting her from working over 40 hours a week. She explicitly requested a temporary accommodation to not work overtime based on this doctor's note. However, Polaris refused to provide the accommodation. They said, we cannot provide that accommodation because overtime is an essential function of this position. Next slide, please. So in the second case, the employer was a specialty medical practice. The pregnant worker was hired as a medical assistant who was required to be on her feet for most of the day, and she wasn't permitted to perform any of her duties while sitting down. She was also not guaranteed any kind of break. The breaks were really dependent on what was going on that day and what the doctors permitted. Next slide, please. So at some point after the employee notified the employer that she was pregnant, her doctor advised her that she needed to periodically sit, take short breaks to eat or drink, and occasionally put her feet up. She especially told her employer that she could do her job if she could sit and rest in between seeing patients or if she could sit while she was logging down patient information in the chart, or alternatively, if she could just take one full 30-minute lunch break per day. However, the employer refused to provide these accommodations, noting that sitting and eating were not part of her job description and medical assistants were not guaranteed lunch breaks. She was actually told that she would be sent home if she needed to sit down at any point while she was at work. Next slide, please. So in both cases, part of the EEOC's allegations against these employers is that the pregnant employees were qualified to protections under the PWFA because any inability to perform the essential functions of their job was temporary and could be performed in the near future, and the inability to perform could be reasonably accommodated. The EEOC is seeking back pay, emotional damages, and punitive damages, among other things, in both of these cases. And in fact, last week, a Florida judge just approved a settlement between the EEOC and another employer that the EEOC sued under the PWFA. In that case, a line cook was fired from a resort when she requested 6 weeks of leave after a stillbirth. The employer agreed in the settlement to pay the employee $100,000 in damages, and the employer is also required to employ a third-party EEO coordinator for 3 years who is supposed to review and revise the employer's discrimination policies. This is obviously a substantial financial impact on this employer. Next slide, please. So the key takeaway to note here is the distinctions between the ADA and the PWFA. So if an employee is alleging an employer violated the ADA, the employee must show that he or she can perform the essential functions of their job with or without a reasonable accommodation. This means that an accommodation is not reasonable if it excuses the employee from performing an essential function of their job. However, the bar is lower for employees under the PWFA. Even if an employee is still temporarily unable to perform the essential functions of their job with an accommodation, the employer must still provide the accommodation so long as it doesn't create an undue hardship. So we can see this in the Polaris case. The EEOC pointed out that even if overtime is an essential function of the employee's job, the PWFA requires an employer to essentially excuse that essential function temporarily. It's a reasonable accommodation under the PWFA to excuse an employee from the essential overtime. The EEOC also is alleging in the complaint that the excused overtime would not be an undue hardship on Polaris because they had other workers who were available to fill in for her, or she could have been reassigned to a different line that didn't require overtime. So what does this mean for employers? Employees are entitled to a broader camp of accommodations under the PWFA than the ADA because employers are required to provide accommodations for any known limitations related to a worker's pregnancy and childbirth, which can simply be related medical appointments. And employers are required to provide accommodations that would temporarily suspend the worker's obligation to perform the essential functions of her job. Next slide, please. We're also having fall breakfast briefings on the PWFA and other information regarding pregnant workers. I know there's sessions in Albany, Saratoga Springs, and Watertown that are coming up later this month. Thank you.
Thank you, Kelly. And we're really glad to have had that presentation because it provides a helpful overview on what the enforcement is looking like in its early stages. And I also thank you for pointing up the way in which the areas under scrutiny, or that better put you focused on your presentation, they fit into a broader framework of laws. And for employers to be thinking about that is really useful. If folks have questions, certainly Kelly or the attorney you work with is available to follow up. And so, speaking of following up, there are a couple questions in the chat, and we'll do our best to attend to them in the time we have remaining. But if we don't, as always, trust that we'll try to get back to you after we conclude in the coming days. And let me switch gears and tell you that for the upcoming webinar on the 22nd, the next Business in 24 Tuesday webinar, we're going to be doing something a little bit different. We're going to have a deep dive on the New York State Clean Slate Act. We're expecting to focus most of the webinar on the implications of the act and otherwise how, as employers, you can prepare for it with the enforcement date sneaking up on us as of next month. So tune in for that. Kristen Smith will be hosting in our normal rotation as between Kristen and me, but the content will be, again, a little bit different than is typical. And we look forward to your feedback, and we're hopeful that it's informative. So if Kathy, you could go to the next slide, please. As Kelly had just mentioned in passing, we have this series of breakfast briefings that are taking place all across the state. So please find the one that is right for you if you haven't already. Those that remain during the month of October are the ones you should be targeting. And let's then think about what's next. I will be with you on the 29th, let me get that right, which is the next time that in 2 weeks from now, I will be hosting. In the interim, again, you're going to have a chance to hear from Kristen and other presenters who will be focusing on the various elements that I just highlighted for the special webinar on the 22nd. If you want to contact any of the presenters for today's webinar, you can certainly do that using the slide that Kathy has just put forward. And you can always contact me if you have questions. I'm happy to point you in the right direction. In the interim, please continue to enjoy fall, hoping that while you pull out that fall clothing, whether that parka or otherwise, that you're enjoying the change of season. And I look forward to seeing you later this month. Thank you.